Okay, today we want to cover conflict of personal laws. This situation arises when two people from different sects intermarry. So a woman could be Sunni and a person could be Shia. And if any dispute arise about the validity of their marriage, about um, dower, maintenance, divorce, or custody of children, or inheritance law. So, which particular personal law will apply and why? This is a conflict of personal laws, and there is also a situation where conflict of laws generally in a situation where laws of different countries apply. So, a person could be Pakistani, might have gone abroad to study and married there to a UK national. Now that person belongs to Pakistan, is Pakistani national, but marries with a person who is based in the UK under UK law. And then they may go on to live in Dubai and they have their children. And then if certain issues arise about the marriage, about custody of children, about inheritance, the laws of which country will apply? Pakistani law will apply. Will it be the UK law where marriage took place, or will it be the laws of Dubai where the couple was residing at the time the dispute arose, or where property is situated? So these are the situations in which um, conflict of laws may arise. Um, and different legal systems respond differently. There might be two types of situations, as I said: conflict of interpersonal laws within one system, or conflict of laws within the legal system where laws of different countries apply. Under conflict of laws or private international law, there are three types of rules which are identified, and courts have to decide that which of these will apply. Lex domicili, law of the domicile of the person, of a person's nationality. Lex loci celebrationis, law of the land where the marriage was solemnized. And lex situs, law of the place where property is situated. So in most of the cases, courts have to decide that which of these three laws will be applied to a particular case. Various jurisdictions have various rules when it comes to the application of private international law. So much so that the scholars have commented that every country has its own private international law. When we look into the family laws in Pakistan, subsection 2 of section 1 of Muslim Family Laws Ordinance 1961 provides that it applies to a citizen of Pakistan wherever they are. But the question arises, what about the people who are dual nationals? Like a person might be Pakistani and might have got US or UK citizenship. Will MFLO still be applicable to them? This is a question that remains unanswered. We have several case law that we have organized under the four headings. First of all, we will look into the effects of religious conversion on marriage. What if a person who's Christian or Hindu becomes Muslim? Can that person divorce his wife under Muslim law? Because we know that the processes for divorce under Hindu and Christian law are very long, whereas under Islamic law, it's very easy. So if a person converts to Islam and pronounces divorce, what about the same person who was previously a Christian or Hindu, was married, embraces Islam, and enter into second marriage? Can he do that? Or is he still bound by the laws of his previous religion? Applicable law of marriage between Muslim and Christian. What's the status of English marriage in Pakistan? Uh, and can a Christian wife of a Muslim husband exercise her right to delegate divorce? What's the legal status of foreign judgments in Pakistan relating to custody of children, alimony, or divorce? And finally, how MFLO applies to Pakistani citizens who live abroad. So let's look into these cases. We have a case that's called Arshad Peter versus Musammat Jmaila, in which it was held that a divorce pronounced by a Christian husband after his conversion to Islam will be effective upon the expiry of either period, and the Christian wife would be entitled to maintenance till that date. So, the moment a person converts to Islam, Islamic law will start become applicable. In a Tariq Masih case, the court held that an adult convert to Islam can enter into a valid nikah without a court order of dissolution of her first marriage. So here, a woman actually converted who was a Christian converted to Islam and entered into a marriage. So it was held that her conversion simply dissolves her Christian marriage and she can enter into a marriage under Islamic law. In 1967 case decided by the Supreme Court of Pakistan, Samuel versus Samuel, it was held that a man who contracts a second marriage after his conversion to Islam, while his first marriage with Christian wife subsists, cannot be held liable for the offense of bigamy, as plurality of wives is permitted in Islam. So I'm not really sure whether in this case they had made a recourse to MFLO, or whether such a person is required to give a notice and get permission from the Union Council as required under MFLO. So because Muslim personal law applies to Muslim citizens of Pakistan, if a person converts from Christianity to Islam, yes, he may enter into second marriage, but he would still be required to follow the processes which are laid down under MFLO. In an interesting case that was decided in 1958, the Lahore High Court, West Pakistan, at that time had made a recourse to equity, justice, and good conscience. So the court held that a Christian who married a Christian wife cannot divorce her under Sharia after embracing Islam, and talaq pronounced by him is invalid. This is very interesting case, so important it is that I want to read certain excerpts from the judgment, and here is one. The court held, it cannot be denied that Divorce Act of 1869 is in full force in Pakistan, and Section 7 of the Act enjoins the court to give relief on principles as nearly as may be conformable to the principles on which the Code of Divorce and Matrimonial Causes in England for the time being acts and gives relief. In Ray, Hammersmith, Superintendent Registrar of Marriages, Mir Anwaruddin, ex parte 1917, the Lord of the King's Bench Division refused to recognize talaq given by a Muslim husband to his Christian wife. In this view of the matter, no court in pre-partition India would have recognized such a talaq. So here you can see that this case is decided not very long after the partition, and courts were simply applying the laws which were pre-partition and even making direct recourse to English case law. In the end, the court held that it would be against the dictates of equity, justice, and good conscience to make a declaration that the plaintiff validly divorced the defendant. So here the plaintiff was a convert to Islam. And as we have seen in previous case that this judgment did not hold its ground and was overruled. But it's very important to bear in mind that this is an important issue that has been adjudicated time and again, and courts have come up with different pronouncement over the period of time. But we have seen that over the period of time, it's Islamic law that has replaced either English law or equity principles. Now it's very much clear that if a person who was a non-Muslim embraces Islam, can exercise his right to dissolve his Christian, Hindu, or Jewish marriage. We have specific case law on Christian divorce, and courts have actually applied Islamic law rather than Christian law or principles of equity, justice, and good conscience in such cases. What's the status of an English marriage in Pakistan? A marriage took place in the UK. What's its status? This is an important case in which there was a split judgment in 1967 by the Supreme Court of Pakistan. There are very few split judgments on family law. This is one of them. So in this case, the court held that the talaq given by the husband to his Christian wife in case of marriage solemnized in London under the English Marriages Act 1949 is valid. So here again, we see that courts are preferring or giving preference to Islamic law over English law. But one of the judges, Justice Yaqub, had dissented in this case. But the majority view was that such a talaq is valid, even though the marriage took place in the UK under English law. We have another important case. In this case, the judgment actually, by applying Islamic law, favored a Christian wife. So in this case, a Christian wife exercised her right to delegated divorce, and the husband says, look, you're a Christian woman, you cannot have a recourse to Islamic law. And the court says, no, she can do that. If a Muslim husband can dissolve his marriage with a Christian woman based on Islamic law, a Christian woman can also divorce herself by exercising the right to delegated divorce explicitly given to her by a Muslim husband. By doing so, courts would actually be applying Islamic family law rather than Christian law. What's the status of foreign judgments? We have specific rules when it comes to CPC, but remember that the strict rules of CPC do not always apply in family courts. So in a case of Dr. Victor Hacker versus Dr. Shaida Mansoor, the Islamabad High Court held that a foreign judgment cannot be enforced in Pakistan if it was not passed on merits and if an appeal was pending against it in the apex court of the respective jurisdiction. And in another case of Peggy Colin versus Muhammad Ishaq Malik, the court held that a decree regarding custody passed in a foreign jurisdiction, the custody of a child can be handed over to a non-Muslim mother of foreign domicile if she is found capable of ensuring a child's welfare and the conduct of the father is blatant disregard of child's welfare. So courts give preference to child's welfare, even if that may be in violation of the principles of Islamic law. So generally, Pakistani courts give preference to family law, but when it comes to the application of welfare of the child, courts are keen to take that into account, even that means giving custody of the child to a mother who is not Muslim and who is a foreigner. In another case, Christian Brass versus Dr. Javed Iqbal, 1981 Peshawar, the court held that in private international law, the principle of welfare of the child determines the jurisdiction of a court. And the court held it will be against the intention of the law if the minor child residing in Pakistan under a Muslim father are entrusted to the petitioner who is a Christian and who's living outside Pakistan to be taken to Canada. So unlike Peggy's case, in this case, the court applied the principle of welfare of the child to deny custody to a Christian foreign women. Um, but there are other cases also, specifically Roshni Desai case, in which a court gave custody of the child to a Hindu Canadian national. What about the application of MFLO to Pakistani citizens who are living abroad? This is an important judgment of the Karachi High Court, where the property was situated in a Middle Eastern country. And the question was whether Section 4 would be applicable. The court held the MFLO applies to Pakistani citizens living abroad, and the Pakistani courts have jurisdiction to administer the estate of a Pakistani disease situated in Pakistan and abroad. Beneficiaries of such estate could include foreigners as well. So this is very, very interesting, very important judgment. So important it is that let's read one excerpt from the judgment. The court held, if a Muslim citizen dies domiciled in Pakistan and leaves property, both immovable and movables, in foreign jurisdiction, the succession to his estate will be according to the rule or Islamic law as modified by Section 4 of the Ordinance. The courts in Pakistan in matters of succession to the estate of a Muslim citizen can apply only his personal law, irrespective of the rules of lex domicili or situs or situs. The only limitation on the jurisdiction of the courts to regulate succession according to personal law of the propositors is the effectiveness of their judgments. This is very, very important judgment. But then we see this 2016 judgment of the Supreme Court, where the court held that courts in Pakistan are bound to apply the principles of private international law wherever necessary. Pakistan courts do not have jurisdiction over properties situated outside Pakistan. In this case, somebody wanted to apply Pakistan succession law to the property which was in the UK. So the court refused and says we are bound to apply private international law, and according to private international law, the law where the property is situated will apply. It will not be the succession law of Pakistan. In this case, the parties were dual national. Now you have to see whether in the next case, if the similar issue arises before the court, whether courts will apply Muhammad Abbas case, Yusuf Abbas case, or they will apply Muhammad Ramzan case. But this is very interesting, and specifically in the context when we have transnational families, so where people belonging to different nationalities enter into marriage and their properties are situated all over the places, these questions become really important. Another important question is about the effect of a Muslim woman's marriage to a Christian man. Such a marriage is not valid under Islamic law. Now, what would be the effect of such a marriage on the right of inheritance? In this case, somebody, a woman married a Christian person, and then her brother says, "Oh, look, because she married a Christian, she does not have right to inheritance in her father's property." The court held, a Muslim female marrying a Christian shall not become non-Muslim merely by the fact of such marriage, though it would be a sinful act, and she shall not be deprived of her right of inheritance from her Muslim parents. It's a very important judgment. Some of you were interested in exploring the right of Muslim female to marry a Christian or Jewish person. So the law as it remains is that such marriage is not valid, but it does not make the person, such a woman, non-Muslim, and it does not affect her inheritance rights. Now, what questions are we left with? So these are important questions that we may like to explore further. Do Pakistani courts recognize marriage that has taken place abroad between a Pakistani citizen and a foreigner? Please analyze the case law on the validity of dissolution of such marriages in Pakistan. Can a Muslim, as a convert from Christianity, dissolve his marriage with a Christian woman through talaq? Please elaborate the development of Pakistani case law on this point. What principles are applied by the Pakistani courts while deciding the custody of children cases regarding transnational families?